The practical consequences of the UPC's long-arm jurisdiction. In Kodak versus Fujifilm, the UPC Court of Appeal has now handed down its first comprehensive decision adopting, not surprisingly, the CJEU's BSH versus Electrolux judgment. The more interesting question now is, how does this work in practice? In my opinion, the court's answer is particularly relevant for non-UPC EU and Lugano states such as Spain and Switzerland, because there the UPC cannot decide validity. Imagine the UPC revokes the patent for the UPC member states. As a consequence, of course, there will be no injunction for the UPC territory. But if the court also concludes that the accused product falls within the claims, it would nevertheless have to grant an injunction for Spain or Switzerland in that case, unless validity is challenged there. Among others, the Court of Appeal addresses exactly this problem. Before granting relief for such non-UPC states, the UPC must notify the defendant and give it an opportunity, normally 2 months, to commence national revocation proceedings. If no such action is filed, the UPC will grant the injunction. If one is filed, the UPC will stay the respective part of the case until the national court has decided on validity. Of course, the position is different for non-UPC states outside the EU and Lugano area, such as the United Kingdom or Turkey. There, following BSH, the UPC may itself consider validity inter partes, so this particular mechanism does not apply. In my view, that procedural framework, not the general adoption of BSH, is the real significance of the decision. Thanks for watching, until next time.